Hello students, welcome to the lecture on Principle Governing Hospitality Operation, and after this lecture we will be able to learn the following objectives. Understand the concept of law, define the international law, explain the law and liability of hotels. Let's start with a brief introduction. Operation management is about the management of the processes that produce or deliver goods and services. Operation management decisions directly affect the size, shape, quantity, quality, price, profitability and speed of delivery of the output of travel, tourism and hospitality organization, whether at the luxury end of the market or a budget product or service. Operation management as a function has changed significantly in recent years as a result of the increasing use of new technologies throughout travel, tourism and hospitality. It has also taken on board new management concepts such as total quality management (TQM) and the attainment of quality standard for product and service benchmarks such as those of the International Organization for Standardization (ISO). Operation management functions in travel, tourism and hospitality include a wide range of activities, many of which are core to the experience of guests and visitors. In travel, tourism and hospitality, the term operation management is not widely employed, with the preference being for functional management responsibilities in the title, given that most businesses in this sector operate a wide range of product and service operation. Let us now discuss the concept of law. Law is a system of rules a society set to maintain order and protect harm to person and property. Such systems are ancient, dating back at least to the Code of Hammurabi, written by an ancient Babylonian king around 1760 BC. Today, most countries have tens or hundreds of thousands of pages of laws. They are enforced by the police, supported by the court and prison system. Laws are written by legislatures such as senators or congressmen. In America and many other countries, these rules must uphold and not contradict the Constitution, a document outlining the most basic rules of the country. Aside from law being a set of rules, the word also refers to the profession practiced by lawyers who either prosecute or defend a client from an accusation of violating the law. Becoming a lawyer requires attending law school and passing a bar exam. This entitles the lawyer to a license. Only lawyers with a license are allowed to practice. In any society, everybody is subject to the law. Everybody must do as the law says or face the punishment which can be handed out to the lawbreakers. Journalists are no different. They too must obey the laws of their society. The law puts limits on each person's freedom in order to protect other person's freedom. We are free to drive a car on the road, but only if we possess a valid driving license, and even then we must keep to one side of the road and obey speed limits and road signs. In this way, although our freedom to drive is restricted, we are protected from other people's careless or unskilled driving, which would make it impossible for us to drive safely at all. Law in business. Effective managers and employees must develop knowledge of both laws and business, because people involved in business also are involved in and greatly affected by the law concerning business. With each passing day, this link between law and business grows even stronger. Sources of law. There are many different sources of law in any society. Some laws will be written in the country's constitution, others will be passed by the legislature, usually a parliament or congress, others will come from long social tradition. Let us consider each main source of law in turn. Constitution. In any country with a written constitution, the constitution will take precedence over any other source of law. For example, if the constitution says there is freedom of speech for all citizens, but the social tradition is for women not to speak in public, a court will protect the right of any woman to speak in public if she chooses to do so. The constitution takes priority over tradition. Customary law. In developing countries which have been decolonized since the 1940s or the 1950s, the law is generally a mixture of law introduced by the former colonial power and customary law which was there before colonization. That customary law often still takes priority in certain areas of life. Common law. English common law is a customary law of England, yet it has become influential in the laws of many other countries. The United States and most countries in the Commonwealth have legal systems based on English common law. If there is nothing in the Constitution to cover a situation and if no specific law has been passed by Parliament to cover a situation, a court in a Commonwealth country may decide the case depending upon English common law. Indeed, some Commonwealth countries have the British House of Lords as their final court of appeal. Legislation. Any law passed by a lawful government which is different from English common law will take precedence over common law. Case law. Case law is the body of available writings explaining the verdicts in a case. It is most often created by judges in their rulings when they write their decisions and give the reasoning behind them, as well as citing precedents in other cases and statutes that had a bearing on their decision. Criminal and civil law. Not all court cases involve crimes. Many of them do, of course, but many others involve what is called civil law rather than criminal law. Criminal law deals with offences by people against society as a whole. Prosecutions are usually brought in the name of the head of state or of the state itself. Civil law deals with offences by people against other individuals. This may include disputes over fences and other land matters, defamation cases, defamed property, broken promises, or a host of other disputes between people. Let us now discuss international law. International law consisted of rules and principles governing the relations and dealings of nations with each other, though recently the scope of international law has been redefined to include relation between states and individuals and relation between international organizations. Public international law concerns itself only with questions of rights between several nations or nations and the citizens or subjects of other nations. In contrast, private international law deals with controversies between private person, natural or juridical, arising out of situation having significant relationship to more than one nation. Public international law. The public variety of this type of law applies when two or more countries or sovereign entities are involved. These laws might cover topics such as human rights, wartime laws, and the laws at sea. Violation of these laws might result in ramifications such as sanctions by other countries, the ending of certain agreements between the countries that are involved, or, in the most severe case, a declaration of war. Private international law. When legal matters involve people, businesses, or private organizations from separate countries rather than government bodies, it is considered private international law. This type of law often involves settling matters such as which country's laws apply or where the case will be decided. It often is necessary for governments to step in to help their citizens settle these matters or to help them achieve a fair result. Domains of international law. International law includes the basic classic concept of law in national legal system: status, property, obligation, and tort. It also includes substantive law, procedure, process, and remedies. International law is rooted in acceptance by the nation states which constitute the system. The following are major substantive fields of international law: international economic law, international security law, international criminal law, international environmental law, international humanitarian law or law of war, international human rights law. International economic law. International economic law is comprised of the legal trade agreements and treaties that support cross-national commercial transactions. The exact parameters of what falls under this umbrella have been changing as the world economic landscape changes in response to the increased globalization of markets. International security law. International security law covers a large number of domestic and international legal issues. These issues and laws are different in each federal government's jurisdiction. Each country's foreign policy interacts directly with its national security law. A variety of government entities work together to manage a nation's national security. International criminal law. International criminal law is used in cases such as war crimes, crimes against humanity, and genocide. These crimes generally are committed against citizens of countries rather than governments, but the crimes are serious enough to cause concern even among nations whose citizens were not targeted. There are no clearly defined parameters in international criminal law, but many nations are able to agree on basic principles of behavior and what is acceptable or unacceptable. International environmental law. International environmental law refers to treaties, statutes, and judicial decisions that involve multiple nations. Improving and creating international environment law is the goal of many conservationist and environmentalist groups who believe that a comprehensive global approach must be taken to stop environmental threats from growing stronger. There are several different ways environmental law can be created, including through protocols and treaties, international courts such as the International Court of Justice, ICJ, and customary law. Diplomatic law. It is a field of international law concerning the practice of diplomacy and the rights and obligation of state representatives on the territory of other states. The broad corpus of diplomatic law derives from one of the oldest principles of customary international law, that of state immunity and sovereign immunity. International humanitarian law. International humanitarian law sets guidelines for armed conflict to protect civilians, prisoners of war, and others from unintended harm. These principles govern how wars are fought and outline basic standards that all member nations ratify through treaties. The Geneva Convention and the Hague Convention formalize laws of war, define war crimes, and provide the framework to prosecute war criminals. International human rights law. International human rights law is a collective term that includes any law, regulation, or treaty agreement that relates to how governments treat certain groups of individuals. Most international human rights laws concern discrimination, racial profiling, gender inequalities, and government-sanctioned violence or torture. Because the laws of each country are different, there is no single international human rights law. Sources of international law. Customary law and conventional law are primary sources of international law. Customary international law results when states follow certain practices generally and consistently out of a sense of legal obligation. Recently, the customary law was codified in the Vienna Convention on the Law of Treaties. Conventional international law derives from international agreements and may take any form that the contracting parties agree upon. Agreements may be made in respect to any matter except to the extent that the agreement conflicts with the rules of international law incorporating basic standards of international conduct or the obligations of a member state under the Charter of the United Nations. Subject of international law. Traditionally, states were the main subject of international law. Increasingly, individuals and non-state international organizations have also become subject to international regulation. The law of nation is a part of the law of the United States unless there is some statute or treaty to the contrary. International law is a part of the law of the United States only for the application of its principles on questions of international rights and duties. It does not restrict the United States or any other nation from making laws governing its own territory. International courts. The most well-known court that decides international legal matters is the International Court of Justice, also known as the World Court, which was established by the United Nations in 1945. Serious matters of public international law are often decided by the United Nations Security Council, which is most concerned with maintaining peace. Law and liability of hotels. Hotels can be defined as commercial establishments that provide lodging and often meals and other services to the public. The word hotel is usually synonymous with inn, especially an inn of high quality. The word inn at common law meant a place where a traveler was furnished with both lodging and entertainment, including food. Any places where transient guests are received and lodged are classified as hotels. The proprietor of an inn or hotel is an innkeeper or hotel keeper, respectively. It is not required that an establishment provides food and drink to its guests in addition to lodging to be a hotel. Applicable regulation. Most establishments are subject to both state and federal law since they are held to be engaged in interstate commerce. Federal law prohibiting discrimination on the basis of race, religion, ethnicity, etc. apply to hotels that are available to the general public, and most states have enacted similar laws as a matter of course. Private clubs which host guests may not be subject to such laws, and it is a question of fact as to whether a locale is a hotel or not. Duty to accept guests. A guest is a transient person who resorts to and is received at an inn for the purpose of obtaining the accommodation which it proposes to afford. But it is essential that a party must be a transit, and if she or he is transit, she or he may become a guest. It is laid down as one of the distinctive features of the relation that a guest is received under an implied contract. Liability to guests. Generally, an innkeeper under the common law doctrine of infra hospitium is strictly liable for loss or damage to a guest's property unless the property is lost or destroyed by an act of God, public enemy, or by the fault of the guest, or from some irresistible force other than the act of God, or from an inevitable accident without fault by the innkeeper. Some jurisdictions allow the innkeeper to exonerate by showing that the loss or injury was not attributable to any fault of the innkeeper or an employee or agent. Removal of guests and guests of guests. An innkeeper gives a general license to all persons to enter his or her inn. It is not a trespass for one to enter an inn without a previous actual invitation. A guest is a paying patron of an inn or hotel. A guest is staying in a hotel for his own purpose. A guest is not interested in the business purposes of a hotel. A voluntary departure without an intention of return terminates the guest relationship. Duties arising out of the innkeeper-guest relationship are terminated when the guest pays the bill and checks out of the hotel. A guest admitted to an inn can be removed thereafter by the innkeeper for refusal to pay his bill, becoming obnoxious to the other guest by his or her own fault, becoming a person of general bad reputation, or behaving in a disorderly manner. Now, in the end, let us summarize what we have learned in this lecture. Operation management decisions directly affect the size, shape, quantity, quality, price, profitability, and speed of delivery of the output of travel, tourism, and hospitality organization, whether at the luxury end of the market or a budget product or service. International law includes the basic classic concepts of law in national legal system: status, property, obligation, and tort. International criminal law is used in cases such as war crimes, crimes against humanity, and genocide. Customary international law results when states follow certain practices generally and consistency out of a sense of legal obligation. International human rights law is a collective term that includes any law, regulation, or treaty agreement that relates to how governments treat certain groups of individuals. A hotel keeper has a lien upon the baggage of any guest which may be in his or her hotel. But to entitle a person to exert an innkeeper lien, she or he must receive property as the goods of a guest.